Chapter 3. Relation between state and federal law. Key exam issues. 1. Erie Doctrine. In a number of situations and for certain issues, the federal courts are required to apply state rather than federal law. Determining whether to apply state or federal law is known as an Erie problem. Erie problems are a favorite source of examination questions. They usually arise in diversity cases, but can arise in others, e.g., supplemental state claims in federal question cases are analyzed similarly. In very general terms, in state law matters in the federal courts, state substantive and federal procedural law are followed. However, determining which law to apply is often more complex. The role and definition of the concepts of substance and procedure vary in different contexts. When either state or federal law might apply, it can help to approach the problem in two stages. A. First, ask whether there is a true conflict. Are there both federal and state rules of law that purport to apply and cannot be harmonized? There is no true conflict if a federal rule or practice does not exist and state law is of a substantive nature, or the federal and state rules, while related, do not speak to exactly the same point, or the two rules agree. In such cases, no choice of one or the other is necessary. B. Second, if there is a true conflict, look to the source of the potentially applicable federal rule of law. The test for the federal rule's validity and governing force varies depending on whether it derives from the Constitution, a statute enacted by Congress, a court rule promulgated under the Rules Enabling Act, or purely from decisional law as opposed to interpretation of the Constitution, an act of Congress, or a federal rule. 1. Is the federal rule of law grounded in the Constitution itself, e.g., the Seventh Amendment guarantee of jury trial in actions at law in the federal courts? If so, the federal rule governs, period, without regard to the source, importance, or substantive nature of any contrary state rule. 2. Is the federal rule of law found in an act of Congress, e.g., a federal statute providing for nationwide service of process? If so, it governs as long as it is constitutional, i.e., it falls within the broad powers of Congress, which include regulation of procedure and, arguably, procedural matters in the federal courts, and Roman II, it does not violate any independent federal constitutional right. 3. Is the federal rule of law a federal rule of civil procedure or evidence or appellate procedure? If so, the Rules Enabling Act 28 U.S.C. 1072 provides the principal test for its validity. It must be arguably procedural, dealing with practice, procedure, or evidence, and must not abridge, enlarge, or modify any substantive right. If it passes these tests and is constitutional, which is practically certain if it satisfies the standards of Section 272, the federal rule governs. 4. Is the federal rule of law judge-made, e.g., the equitable doctrine of lashes? If so, it should not govern in federal court if it fails the twin aims test of Erie, as stated in Hanna v. Plumer. If the federal courts do not follow the state rule, will it encourage forum shopping between state and federal courts and inequitable administration of the laws by providing different and possibly outcome-affecting regimes of applicable law? Certain judge-made law cases involve an essential characteristic of the federal court system, such as relations among the jury, trial judge, and appellate court. In such cases, it might be necessary to balance state interests against those served by a decisional federal rule, or to see whether the state and federal interests both can be accommodated. 2. Federal common law. Some civil procedure courses will also include coverage of federal common law. Although in Erie the Supreme Court stated that there is no federal general common law emphasis added, in several areas of special federal authority or interest, the federal courts may develop federal common law by borrowing or even preempting state law. You may need to ask whether a case involves a need to borrow state law, such as a statute of limitations for a federal claim when Congress has enacted none. Roman II, an express or implied authorization from Congress for the federal courts to develop federal common law. Or Roman III, a federal interest significant enough to call for uniform federal decisional law. A. State law in the federal courts. 1. Rules of Decision Act 531. The starting point for the applicability of state law in the federal courts is the Rules of Decision Act 28 U.S.C. 18652, originally adopted in 18789. In its present form, the Act provides, "The laws of the several states, except where the Constitution or treaties of the United States or acts of Congress otherwise require or provide, shall be regarded as rules of decision in civil actions in the courts of the United States, in cases where they apply." 2. Former Rule Swift v. Tyson 532. For almost a century, the prevailing interpretation of the reference to state laws in the Rules of Decision Act was that it did not include state common law of a general, as opposed to local, nature. Thus, the federal courts could and did follow their own view of what the general common law was or should be. Swift v. Tyson, 41 U.S. 16 Pet. 11842. The federal court's decisions on this general common law, however, were not binding precedent on the courts of the states. Consequently, different rules of substantive law could apply to the same transaction, depending on whether litigation took place in state or federal court. A. Note: even under Swift, federal courts were bound by applicable state statutes as long as they were constitutional and local common law, e.g., state common law regarding rights in real property within the states. 3. Difficulties of Swift Regime 533. The approach taken in Swift became vulnerable for several reasons. A. Changing attitudes toward Law 534. Swift appeared to rest in part on a view that a true common law existed and could be found by the courts. However, many legal authorities moved away from this view and accepted the idea that each state could have its own internally authoritative common law, and that variations among states on the same point did not mean that some had to be wrong. B. Failure to achieve uniformity 535. Swift also became vulnerable because it failed to help develop a uniform common law, due to the disagreement of many state courts with the general common law established by the federal courts. Thus, Swift came to be seen as allowing the federal courts to add one more regime of common law, rather than taking part in the development of one true set of common law doctrines. C. Practical difficulties and unfairness 536. Swift led to forum shopping. Because the federal courts often applied common law rules different from the law of the states in which they sat, litigants could manipulate federal jurisdiction to gain favorable substantive law. That is unfair because parties who are similarly situated, except for litigating in different court systems within the same state, can be governed by different substantive rules. This disparity undermines the ends of state common law rules and complicates private planning, because parties cannot be sure what law will govern their affairs. Example: Black and White Taxicab Co. The height of such manipulation came in Black and White Taxicab Co. v. Brown and Yellow Taxicab Co. 276 U.S. 518 1928, in which the plaintiff avoided a state common law anti-monopoly rule by reincorporating in another state and then bringing a diversity action in federal court, which followed a different rule under which the challenged exclusive dealing agreement was lawful. D. Doubts about Swift Interpretation 537. Swift also came into doubt because historical research on the adoption of the original Rules of Decision Act questioned whether the drafters had intended to exclude general common law from the term laws of the several states, see supra. 531-532. Warren, New Light on the History of the Federal Judiciary Act of 1789, 37 Harv. L. Rabbit. 49 1923. Later research has raised doubt about whether Professor Warren interpreted the historical materials correctly, but the Erie Court relied in part on Warren's view in overruling Swift, and the later questioning has not yet played a role in modern Erie jurisprudence. E. Views on the constitutional scope of federal power 538. Finally, there seemed to be no constitutional basis for the federal court's lawmaking authority that existed under Swift. The decision appeared to presume a general law-making power in the federal courts of a sort that the Constitution does not grant to Congress, and which Congress had not attempted to confer on the federal courts. See Infra 547. 4. Overruling of Swift by Erie 539. The combination of the above problems contributed to the overruling of Swift in Erie Railroad v. Tompkins, 304 U.S. 64, 1938. Erie held that in the absence of an act of Congress providing governing law, a federal court should follow applicable state common law principles rather than developing and applying its own general common law. At issue was the liability of a railroad for injury to a person who was struck by an object protruding from a passing train. Today, the issue of what substantive law governs in cases like Erie itself is often simple, but the decision made broad changes whose ramifications are still being worked out in the federal courts today. A reasoning of Erie 540. Erie clearly identified three distinct rationales for the decision. 1. Statutory Interpretation 541. The court accepted the argument that the language of the Rules of Decision Act was not intended to exclude all state general common law. See Supra 537. Instead, the term laws of the several states includes state common law, general and local, as well as positive law like state constitutions, statutes, regulations, and ordinances. 2. Lack of uniformity and resulting discrimination 542. The Erie majority also noted the persistence of differing views on common law questions between the state and federal courts, and the possibility this created for discrimination among litigants depending on the forum in which the case was tried. A. Note Equal Protection, Red Herring 543. In this non-constitutional portion of its opinion, the court stated that the Swift doctrine had rendered impossible the equal protection of the law. This misleading phrasing often makes students think that Erie rests on the Equal Protection Clause of the 14th Amendment. This cannot be true because Swift was a federal law ruling. The Equal Protection Clause speaks to the states and had not yet been held applicable to the federal government at the time Erie was decided. Instead, the term equal protection here must refer to the serious, but non-constitutional, problems of non-uniformity in administration of state law and unfairly disparate treatment of litigants depending on whether a case is in state or federal court. B. Discrimination by non-citizens against citizens 544. In this second part of the opinion, the Erie majority also said that Swift had introduced grave discrimination by non-citizens against citizens, a concept repeated in some later opinions in the Erie line of cases. The reference is to the ability that an out-of-state party often has to control the choice of forum federal or state in diversity litigation, e.g., an out-of-state plaintiff may decide to sue in the defendant's home state court, in which case the defendant cannot remove to federal court 28 U.S.C. 12441b. See Supra 495. An out-of-state defendant often, but not always, can effect removal to federal court if sued in state court. See Supra 484 et seq. Regardless of who controls the forum choice, discrimination among litigants depending on the forum and what law it may apply remains a concern. 3. Unconstitutionality of Swift Interpretation 545. Whatever the persuasiveness of the above 2 points, erroneous statutory interpretation and resulting discrimination, the court in Erie stated that it would not have been prepared to abandon the long-established Swift doctrine were it not convinced of Swift's unconstitutionality. A. Holding, not dictum 546. Because the court explicitly said that the constitutional ground was essential to the result in Erie, the constitutional portion of the opinion, despite some questioning, qualifies as a holding rather than dictum. B. Basis of unconstitutionality 547. The court did not clearly explain why the Swift interpretation of the Rules of Decision Act was unconstitutional. It did not find that SWIFT violated any specific clause, but rather noted the absence of any clause in the Constitution purporting to confer upon either Congress or the federal courts a general power to declare substantive rules of common law applicable in a state. The court explained that the Constitution preserves the autonomy of the states, and supplanting their law with federal law is permissible only pursuant to powers specifically granted to the federal government by the Constitution. 1. Note 10th Amendment alone, not basis of Erie 548. The 10th Amendment's reservation of undelegated powers to the states or the people reinforces this argument, but by itself does not establish the unconstitutionality of SWIFT. The SWIFT interpretation probably would be unconstitutional under modern views even if there were no 10th Amendment, because the interpretation presumes a general law, making power that has not been granted to the federal government. 2. Commerce power a possible basis. 549. Because the accident giving rise to the Erie litigation involved an interstate railroad, students sometimes wonder whether Erie did not overlook a possible basis for federal law in the commerce power. The Constitution does grant Congress pervasive power over interstate commerce. Pursuant to this power, Congress could have provided for substantive tort law to govern accidents involving interstate commerce, or perhaps it could have authorized the federal courts to develop applicable common law in the area. However, Congress had not done so and still has not. Thus, the court had to examine whether the federal courts had the power to create a general federal common law. It concluded that they did not, leaving state law the only law that could govern without congressional legislation. B. Erie as part of a revolution in federal court practice 550. Erie coincided with the adoption of the federal rules of civil procedure, before which federal courts had largely followed the procedural rules of the state courts in which they sat. Thus, in the same year, the federal courts moved sharply in opposite directions, under Erie toward more application of state substantive law rather than general common law, and Roman II under the federal rules toward uniform federal procedural law in place of diverse local practice. The approach to deciding when to apply federal procedural law in diversity cases, however, remained problematic for some time. C. Principal cases developing Erie 551. Erie solved many old problems but opened up new ones, especially in cases in which the competing federal and state rules that might apply were in the borderland between substance and procedure. The Supreme Court has repeatedly said that in matters in the federal courts arising under state law, the general guideline is that state substantive law and federal procedural law govern. However, the distinction between substance and procedure is not always clear, unvarying, or mechanical. The role and definition of these concepts vary depending on the context. Major cases in the first decades after Erie dealt in differing ways with these problems. Two of them, York and Bayard, infra, often receive great emphasis in teaching, but are of limited practical significance today. 1. Guarantee Trust Co. v. York 552. Guarantee Trust Co. v. York 326 U.S. 1945, on somewhat complicated facts, presented the question whether a state statute of limitations or the more flexible federal decisional rule of lashes, which asks whether delay has been excessive and caused the other side prejudice, should determine the timeliness of an equitable state law claim filed in federal court. A. Specific Holding 553. The court ruled that the New York statute of limitations governed, rather than the federal lashes doctrine. This result makes sense because statutes of limitations, although partly reflecting procedural concerns about courts' ability to deal with stale claims, also have strong substantive overtones in that they provide for repose when the time to sue has passed. People can stop worrying about being sued, close their books on past transactions, make plans unaffected by the possibility of litigation, and get on with their lives and businesses. 1. Note: regardless of the fluctuations in the Erie doctrine since York, this holding treating state statutes of limitations as substantive for Erie purposes still stands. B. Outcome Determination, Test 554. In explaining the York ruling, the court articulated what came to be a major test for whether state law should be regarded as substantive for Erie purposes. Will application of federal law instead of the state law significantly affect the outcome of the litigation? 1. Difficulties of the Test 555. It is hard to know where to stop in applying the York test. If applied broadly, almost any procedural rule could qualify as substantive because especially if disobeyed it could affect the outcome of a case. In fact, some cases applying the test appeared to raise doubts about whether many federal rules of civil procedure could govern when state law differed. But the Supreme Court has subsequently drawn back from the most far-reaching readings of York. 2. Possible overreading of Test 556. It seems doubtful that the outcome determination test should have been read with such a vengeance, for it was contrasted with whether a state rule concerns merely the manner or means by which a right to recover is enforced, i.e., even under York, if a state rule concerned only the manner or means of enforcement, federal law could govern. The opinion also pointed out that the concern was to avoid providing litigants with a second, conflicting body of law. This dual regime concern remains valid and is often a useful tool for discerning whether a serious Erie problem exists. 2. Byard and the Interest Balancing Approach 557. In Byard v. Blue Ridge Electric Cooperative, Inc., 356 U.S. 525, 1958, the court appeared to signal another departure by at least demoting the outcome determination factor to one among several to be balanced along with federal and state interests in the rules that could be applied. This came to be known as an interest balancing approach to Erie problems. A. Specific Holding 558. Byard was a federal diversity case. The issue was whether federal or state law should govern the manner of determining an ancillary state law issue, the status of an outside contractor's employee under a workers' compensation law. Under state practice, the judge determined status. In federal court, such issues went to the jury. The court held in favor of the federal rule. 1. Note: a federal court might reach the same result today if Byard arose as a case of first impression by application of the Seventh Amendment jury trial right as it is now interpreted. At the time, though, the court did not treat the result as required by the Seventh Amendment. B. Balancing Approach 559. Byard discusses three main types of factors that could bear on the choice between the state and federal rules. 1. Relation between state rule in question and underlying state right 560. The court first asked whether the state practice was bound up with the underlying state law rights and obligations being enforced, and concluded that it was not. The aim of this inquiry seems to have been to determine whether the state procedural practice was an integral part of the state's substantive right, or if the state system followed it for some independent reason that might relate more to state court internal housekeeping, and, therefore, have less call to be followed in federal court. Compare malpractice screening panels. Several federal courts have followed state law requirements for screening panels in medical malpractice suits, on the theory that the procedural mechanism was adopted for purposes related to the legislature's views on the enforcement of the underlying tort claims themselves. See, e.g., D'Antonio v. Northampton Accomack General Hospital, 628 F2D 287 4th Sir. 1980. 2. Countervailing Interests of the Federal Judicial System 561. The Byard Court also looked to the strength of the federal policy involved, i.e., the relationship between judge and jury in federal court, and the danger that following the state rule would disrupt that policy. The federal interests relevant to this inquiry fall into a narrow range. They do not pertain to the substance of the law, but rather involve the federal court's interest in their own smooth functioning, and in the uniformity and coherence of the decisional principles they have evolved to govern their procedures. 3. Likelihood of effect on outcome 562. Finally, the court looked to the York outcome determination test and decided that following the federal practice would not likely have an effect on the outcome of the suit. C. Views on balancing approach 563. Bayard drew praise for recognizing the relevance of federal as well as state concerns, for bringing to the surface factors bearing on choices between state and federal law in a complex system, and for reducing the threat that the federal rules of civil procedure would so often have to yield to state rules as to produce a patchwork and undermine the uniformity sought and achieved by adoption of the rules. However, Bayard suffers from the common difficulties of multifactor balancing approaches. It has the apples and oranges problem, for it is hard to find a scale on which to balance state and federal interests of different types, and inconsistency in application can often result. D. Status of Bayard Test 564. For many years, starting with Hanna v. Plumer discussed below, the Supreme Court virtually ignored Bayard and emphasized other approaches set out in Hanna and applied in later cases. However, the court never disavowed or overruled Bayard, thus leaving doubt as to whether that case remained good law in any respect. In 1996, the court revived Bayard to a limited extent, invoking it when the possibly applicable federal rule of law was purely decisional and might involve an essential characteristic of the federal court system, e.g., some aspects of the relationship among the jury, trial judge, and appellate court. Gasparini v. Center for Humanities, Inc., 518 U.S. 415 1996. In Gasparini, a diversity defendant appealed a jury award, claiming that it was excessive. Had the case been in state court, appellate review would have been de novo and the court would apply the state standard for excessiveness, which looked to whether the verdict departs materially from what would be reasonable compensation. Federal appellate courts, by contrast, apply the deferential abuse of discretion standard when reviewing federal trial courts' rulings on such matters. The Supreme Court held that the state interest in application of its substantive standard, and the federal interest in the relationship between federal trial and appellate courts, could be accommodated by having the federal trial court apply the state's departs materially standard, with federal appellate review of the district court's resulting ruling being for abuse of discretion only. 5. Approach under Hanna v. Plumer 565. Until 1965, the Supreme Court treated many federal vs. state law problems as subject to a general Erie approach, as developed through York and Bayard. However, when federal rules of civil procedure arguably conflicted with the law that would apply in state courts, a parallel but mostly independent line of cases developed. The court sorted out the different law choice situations and refined the approaches applicable to each in Hanna v. Plumer, 380 U.S., 460 1965. A. Specific Holding 566. In Hanna, the Supreme Court held that Federal Rule of Civil Procedure 4D1, now Rule 4E2B, allowing substituted service of process on a defendant's spouse at their home, rather than the personal service required by Massachusetts law, was valid and controlling, even though the substituted service would not have sufficed had the same state law action been brought in Massachusetts state court. 1. Note: the situation incidentally illustrates the possible overextension of the outcome determination test, for if the state rule applied in federal court, the suit would have been dismissed because state requirements had not been met. B. Two parts of Hanna Opinion 567. It is perhaps not frequently enough noticed that the majority opinion in Hanna has two parts. The first, technically dictum, about the Erie Rule, and the second, being the court's holding, about the tests for the validity of a rule adopted pursuant to the Rules Enabling Act 28 U.S.C. 2072. 1. Erie Dictum in Hanna 568. The first part of the opinion confirms the scaling back of the York outcome determination test. It suggests, and later opinions appear to confirm, that while the test survives, it is to be applied in modified form in light of the policies underlying the Erie Rule. The court identified these policies as the twin aims of discouragement of forum shopping and avoidance of inequitable administration of the laws. A. Application. Although the court decided that Hanna was not the type of case to which the modified York test applied C infra, the court implied that if it did apply, the federal rule would govern because the different rules in federal and state court regarding service of process would neither encourage forum shopping nor cause unfair discrimination among litigants. B. Comment on forum shopping. Forum shopping is not always an evil. The very existence of diversity jurisdiction, concurrent with state courts' general jurisdiction, reflects an intent to let some litigants choose between forums. By itself, forum shopping seems at most a minor irritant, involving some procedural shuffling. The main difficulty appears to be with what litigants may get when they forum shop an unfairly different rule of law from what would have governed in state court. Consequently, although Supreme Court opinions regularly mention the forum shopping concern, it should not be treated in isolation, but rather should be considered in tandem with the aim of discouraging inequitable administration of the laws. 2. Holding with respect to validity of Federal Rules 569. In the holding portion of Hanna, the court found that the modified York approach developed in the dictum portion of Hanna supra applied to the typical, relatively unguided Erie choice, but did not apply here because Congress had provided a different standard in the Rules Enabling Act, under which the federal rules are promulgated. That act gives the Supreme Court the power to adopt federal rules regarding practice, procedure, and evidence in the federal courts, as long as the rules do not abridge, enlarge, or modify any substantive right. Under the Enabling Act, the Hanna Court ruled that the federal rules are to be applied in federal courts unless they violate the Constitution or the terms of the Enabling Act itself. A. Constitutional Restrictions 570. Recall that the power of the federal courts to create general common law was held unconstitutional because it did not rest on a power granted to the federal government by the Constitution. See Supra 547. The power to regulate procedure in the federal courts, however, has been granted to Congress under the constitutional provision creating lower federal courts art. Roman 3:1, as augmented by the necessary and proper clause art. I. 17C Constitutional Law Summary, and Congress has delegated part of this power to the Supreme Court through the Rules Enabling Act. The only constitutional restriction on this power is that the rules be arguably procedural. The power to make procedural rules is broad enough to include matters which, though falling within the uncertain area between substance and procedure, are rationally capable of classification as either. Hanna v. Plumer, Supra. B. Enabling Act Limitations. 1. Practice and Procedure Requirement 571. In Hanna, the court reiterated that a rule passes muster under the Practice and Procedure portion of the Enabling Act if it really regulates procedure, the judicial process for enforcing rights and duties recognized by substantive law and for justly administering remedy and redress for disregard or infraction of them. It is highly unlikely that any federal rule the court might plausibly promulgate could fail this test. 2. Substantive Rights Limitation 572. The second sentence of the Rules Enabling Act requires that the rules not abridge, enlarge, or modify any substantive right, and to be valid a rule technically must not transgress this prescription. However, in Hanna, the court pointed out that this limitation is not addressed to merely incidental effects on the rights of litigants. C. Strong Presumption of Validity 573. The Hanna Court made it clear that when there is a conflict between a federal rule and state law, there is a very strong presumption in favor of the validity of the federal rule. It stated that the rule is to be applied unless it appears that the Rules Advisory Committee, the Supreme Court, and Congress erred in their initial judgment that the rule did not transgress the Enabling Act or the Constitution. Indeed, the Supreme Court has never held a federal rule invalid on its face or as applied. C. Justice Harlan's Concurrence 574. Justice Harlan concurred in the Hanna judgment, but criticized the majority as going too far in the direction of favoring the federal rules. He characterized the court's approach as arguably procedural, ergo constitutional. As to the federal rules, this characterization may understate Hanna's requirements, at least if the court were to give some effect to the Enabling Act's substantive rights limitation. On the other hand, Harlan's characterization seems accurate when Congress itself has enacted legislation regulating procedure in the federal courts, e.g., venue rules, see Supra 143 et seq. However, such a relaxed standard for validity is not objectionable in the context of a procedural rule for federal courts enacted by Congress. Rationale: Congress has broad power over procedure in the federal courts and is not bound by the Enabling Act's restriction against affecting substantive rights. 1. Primary private activity 575. Justice Harlan also argued for an approach to federal vs. state rule choice that would have emphasized state power over primary private activity, i.e., state rule would apply if it would affect the primary, out-of-court stages of activity from which a case arises. Federal rule would apply if it affected in-court behavior following the primary stages. Although thoughtfully advocated, this view has not prevailed, and if turned into a single approach, it would overlook the multiple nature of modern Erie-Hanna analyses. 6. Modern approach under Erie and Hanna 576. The Hanna opinion suggests an approach to analysis of many federal state law choice issues, amplified in an important article. Ely, The Irrepressible Myth of Erie, 87 Harv. L. Rev. 693 1974 First. It is necessary to see whether any choice is needed. There may be no conflict to resolve between federal and state rules. Second, if conflict exists, one should determine the source of the arguably applicable federal rule of law, the Constitution, an act of Congress, a federal rule of civil or appellate procedure or evidence, or a decisional rule developed by the federal courts and not resting on interpretation of one of the foregoing sources. The source of the federal rule determines the test for its validity and governing force. A. Conflict Determination Stage 577. For several reasons, federal and state rules of law that might apply in a situation may not conflict. E.g., only one system may purport to have an applicable rule at all, or the two rules may address somewhat different, even if closely related, points and may both be applied. Or the rules may agree and thus call for the same result, whichever is applied. If so, no Hanna analysis is necessary, although in the absence of an applicable federal rule of civil procedure, the Erie concern for inequitable administration of the laws may clinch the case for application of the state rule. Walker v. Armco Steel Corp., 446 U.S., 740 1980. 1. Illustration: No Federal Rule 578. After Erie, in the absence of action by Congress, there is no federal law that purports to govern in many common tort situations. The only substantive law that can govern is state law. 2. Illustration: No Direct Conflict 579. Federal Rule 3, which states that a civil action is commenced by filing a complaint with the court, need not be read as speaking to when a state statute of limitations is told on a state cause of action. Thus, if state law provides that the action is not told until process is served, the service requirement being an integral part of the state limitations statute, the state rule applies in state law actions in federal court, rendering the Hanna analysis inapplicable. Walker v. Armco Steel Corp. Supra, Ragan v. Merchants Transfer and Warehouse Co., 337 U.S., 530 1949. 3. Uncertainty about construction to avoid conflict 580. The court has stated that federal rules should be given their plain meaning. If that reading leads to a direct collision with state law, the Hanna analysis applies. Walker v. Armco Steel Corp. Supra. This position suggests that a federal rule should not be narrowly construed to avoid conflict with state law. However, the court has indicated that the federal rules should be interpreted with sensitivity to important state interests and regulatory policies. Gasparini v. Center for Humanities. Supra, which may permit a finding of no direct conflict between state and federal laws. The court has also been willing to adopt limiting constructions of federal rules to minimize or avoid problems with the Rules Enabling Act's substantive rights limitation. See Supra. 572. Semtech International Inc. v. Lockheed Martin Corp. 531 U.S. 497 2001. Ortiz v. Fiberboard Corp. 527 U.S. 815 1999. Example HANA. In HANA itself, conflict could have been avoided by reading Federal Rule 4D1 to deal only with service to commence the action and not with tolling the statute of limitations. State law provided for tolling either by personal service or by filing a notice of claim in probate court. The plaintiff might thus have followed both federal and state law by using substituted service under Rule 4 and tolling the statute by filing a notice of claim. The court did not take this course, however, saying that the federal rule reflected a determination that the notice purposes of state law could be achieved by less cumbersome means, and that the rule implied that in-hand service was not required in federal court actions. 4. Illustration Parallel Rules or Borrowing. 581. Another reason why no conflict may exist is that many state court rules closely track the federal rules, and some of the federal rules were originally modeled on state rules, so that the two provisions may be identical in phrasing or effect. Moreover, federal rules, such as Federal Rule 4 on service of process, sometimes borrow certain types of state law provisions from the state in which the district court sits. This precludes the possibility of conflict to the extent that the federal rule is borrowed state law. B. Conflict Resolution Stage 582. If the federal and state rules conflict, it is necessary to proceed to the HANA analysis. In applying that analysis, it is essential first to determine the source of the potentially applicable federal rule of law. The answer to that inquiry provides the approach for determining whether the federal rule is valid. If so, under the Supremacy Clause U.S. Const. Art. Roman 6:2 it prevails over contrary state law. 1. Federal Constitution 583. Some procedural rules that govern in federal court derive from the text and judicial interpretations of the United States Constitution, such as the Seventh Amendment guarantee of the right to trial by jury in suits at common law, which does not apply to state courts. Because the Constitution is our paramount law, if it speaks to a situation before a court, it governs, without regard to any contrary state law or practice. This situation provides a possibly oversimplified example of why one should not invariably think in the Erie context in terms of substance vs. procedure. Such labels, about either state or federal law, are totally beside the point if the source of a rule of federal law is the Constitution itself. 2. Acts of Congress 584. Because of Congress's broad constitutional power over federal courts, see Supra. 570. If Congress passes a statute governing federal court procedure, that statute is valid and prevails over any contrary state law if it is arguably procedural. Thus, one should look only to the procedural nature of the federal statute in determining whether it is valid and governing. The substantive nature of any contrary state rule would be irrelevant, and there is no place for Bayard's balancing of state and federal interests, because Congress has already done the balancing. Example: Federal Transfer of Venue Statute. Although Alabama law that would govern in an action conducted in Alabama state court disfavored contractual forum selection clauses, 28 U.S.C. Section 1T404A on transfer of venue between federal courts, see Supra. 191 et seq. was sufficiently broad to cover and governed in a state law case in Alabama federal court. Thus, the federal court could consider the effect of the parties' forum selection clause on possible transfer to federal court in New York. Stewart Organization v. Rico Corp. Supra. 223. 3. Federal Rules 585. A federal rule promulgated pursuant to the Rules Enabling Act is judged by the standards of the Act, as reflected in the holding portion of HANA v. Plumer, Supra. The rule, including court interpretations of the rule, is to be applied instead of contrary state law unless it appears that the relevant advisory committees on civil rules, appellate rules, rules of evidence, etc. draft proposed rules for the Judicial Conference of the United States, which recommends them for adoption by the Supreme Court. The Supreme Court and Congress erred in their initial judgment that the rule did not transgress the Rules Enabling Act or the Constitution. Congress does not usually vote on proposed rules, but they must be submitted to Congress at least 7 months before they are to take effect. 28 U.S.C. 274. If Congress does not act, the rules go into effect. Example: Federal Rule of Appellate Procedure 38, which allows discretionary penalties for frivolous appeals, prevailed in federal court over an Alabama statute requiring penalties for unsuccessful appeals in state court. Burlington Northern Railroad v. Woods, 480 U.S. 1, 1987. Compare possible counterexample: the leading case in a court of appeals declining to apply an applicable federal rule, because of conflict with a state rule it regarded as substantive, involved a liberal Massachusetts rule on relation back for party changes in pleading amendments. The First Circuit held that then applicable Federal Rule L5C's restrictive approach to relation back, since relaxed by amendment of the rule, see infra 975, would defeat rights arising from state substantive law and followed the state rule. Marshall v. Mulrenin, 508 F2D 39 First Sir. 1974. It seems doubtful that the Supreme Court would approve the approach in Mulrenin if a similar case were to come before it today, because of its strong emphasis on the presumptive validity of a federal rule that qualifies as procedural, and its willingness to tolerate incidental effects of the rules on the enforcement of state law rights. A. Rules Enabling Acts, Substantive Right Limitation 586. Whether the court would ever strike down a federal rule for violating the Enabling Act seems to depend primarily on whether it would be willing to give significant independent force to the portion of the Enabling Act that requires that the rules not abridge, enlarge, or modify any substantive right. Most often, procedural rules will not have anything like the forbidden effect, so the problem will rarely arise. 1. Incidental Effects 587. The court has disregarded incidental effects that leave untouched the content of state substantive law, while providing a somewhat different manner or means to enforce it. Example: the court has held that any effect on substantive rights resulting from the imposition of Rule 11 regarding improper assertion of claims or defenses, see infra 809 et seq. Sanctions is incidental, and that the rule governs in diversity cases. Business Guides, Inc. v. Chromatic Communications Enterprises, Inc., 498 U.S. 533 1991. 2. Possibility of conflict with substantive right 588. The court has not, thus far, entertained the possibility that a generally valid federal rule might, in particular contexts, impermissibly conflict with a substantive right, as the First Circuit concluded had happened in Marshall, supra. The court has, however, been willing to adopt limiting constructions of federal rules of civil procedure to minimize or avoid problems with the Rules Enabling Act's substantive rights limitation, see supra 572. Semtech International Inc. v. Lockheed Martin Corp. supra 580. Ortiz v. Fiberboard Corp. supra 580. 4. Judge made Federal Procedural Rules 589. If a potentially applicable federal rule is purely decisional, i.e., not the result of an interpretation of positive law found in the Constitution, an act of Congress, or a federal rule, the twin aims Erie test articulated in the dictum portion of the Hanna opinion governs, if applying the federal judge-made rule would counter the aims of discouraging forum shopping and avoiding inequitable administration of the laws, the federal court should follow state law. Example: Guarantee Trust Co. v. York, supra 552, remains a prime illustration of such a situation, although the court's analysis when it decided York was somewhat different from the modern approach under Hanna. Today, federal courts would apply the state rule in a case like York because following the federal rule would fail the twin aims test, a party who would be barred by a statute of limitations in state court, but might be able to argue around a more flexible federal judge-made lashes rule, would be tempted to file in federal court, and entertaining the action in federal court, when it would be barred by limitations in state court, would also deprive the defendant of the benefits of repose meant to be conferred by the state statute. A. Note: the twin aims approach might also apply and cut against the applicability of state law in federal court. If state courts have a rule governing purely internal housekeeping matters, such as judicial attire or length of paper for court filings, and federal courts have nothing that amounts to a rule, but do have a practice differing from that followed in state court. B. Caution: the court has also shown a willingness to consider possible outcome variation and forum choice influence in interpreting a federal rule of civil procedure, thus possibly making the twin aims approach relevant in at least some cases besides those involving purely decisional federal procedural rules or non-rule practices. See Semtech International Inc. v. Lockheed Martin Corp. Supra 580, declining to give Rule 41B's provision that most dismissals operate as an adjudication on the merits full claim preclusive effect when the district court dismissed based on the statute of limitations, and courts of the state in which the district court sat would not treat such a dismissal as extinguishing the substantive right. The court noted that otherwise defendants would have an incentive to remove diversity cases to federal court to obtain a broader preclusive effect. C. Sufficiency of evidence 590. In state law cases in the federal courts, the lower federal courts are divided on whether to apply state or judge-made federal standards to the issue of whether the evidence is sufficient for a case to go to the jury. The trend in the cases, however, appears to be toward the federal standard because the question goes to whether judge or jury should evaluate the sufficiency of the evidence, not to the elements of the claim or the definition of the persuasion burden. Mayer v. Gary Partners & Co., 29 F3D 337 Sir, 1994. 1. But note standard for reviewing jury awards 591. When a federal trial judge considers a new trial motion based on alleged excessiveness of a jury's award in a state law case, state rather than federal law supplies the governing standard because it reflects state policy on how much of a check to place on excessive damages. Gasparini v. Center for Humanities, Inc., Supra 564. D. Relative infrequency of problems of this sort 592. Because federal statutes and the federal rules cover federal procedural issues fairly broadly, and because federal decisional rules often will not conflict with potentially applicable state rules, judge-made federal law infrequently comes into play in state vs. federal law conflicts. Nevertheless, later cases discussing Hanna explicitly endorsed the twin aims analysis for this type of situation. See, e.g., Stewart Organization v. Rico Corp. Supra 584. 1. NASCO case. In 1991, for the first time since before Hanna, the Supreme Court faced a case involving what it viewed as a conflict between state law and judge-made federal procedural law. Chambers v. NASCO, Inc., 501 U.S. 32 1991. NASCO involved the inherent power of federal courts to impose sanctions for bad faith conduct in litigation before the courts, even in state law cases where the state courts would not have a similar sanctioning power. The majority opinion routinely invoked the twin aims approach, found no forum shopping incentives or inequity, and upheld the federal rule. 2. Cautionary note. Because the two prominent intermediate cases of York and Byard involved what the court treated as a conflict between state law and judge-made federal law, students often mistakenly regard them as dominating the field of eerie problems. The court has, however, made it clear that other tests for the validity and governing force of a federal rule apply when the rule is grounded in the Constitution itself, enacted by Congress, or promulgated pursuant to the Enabling Act. E. Limited survival of Byard Approach 593. The survival of Bayed's balancing or accommodation of state and federal interests appears to be limited to a subpart of this category of cases involving judge-made federal procedural law when an as of yet not clearly defined essential characteristic of the federal court system, likely implicating relations among jury, trial judge, and appellate court, is involved. See Gasparini v. Center for Humanities, Inc. Supra. Such balancing or accommodation appears uncalled for in cases involving positive federal law, because other authoritative lawmakers, the Constitution drafters, Congress, or the federal rules makers have already done the balancing or accommodating. Even with purely decisional federal rules, the Court's decisions since Hanna indicate that the purposive twin aims modified version of the York test, rather than Bayard interest analysis, is the approach to be followed, unless an essential characteristic of the federal court system is involved. Example Hanna. In Hanna itself, the Court said that the importance of a state rule is relevant in the Erie context only for purposes of determining whether failing to follow the state rule in federal court would disserve the twin aims of discouraging forum shopping and avoiding inequitable administration of the laws. Example NASCO. In NASCO Supra, in upholding the federal court's decisionally established inherent authority to impose sanctions for bad faith conduct in state law litigation before them despite contrary state law, the Court relied on Erie, York, and Hanna but ignored Bayard. Example Gasparini. In Gasparini c. Supra 564, the Court relied on Bayard, but only concerning the scope of federal appellate review of trial court denials of motions seeking remittiture, which involves relations among federal juries, trial judges, and appellate courts. In choosing state law over the federal standard for trial judges' review of jury verdicts for excessiveness in state law cases. However, the Court in Gasparini again used the twin aims test and relied on Erie, York, and Hanna while ignoring Bayard. 7. Which state's law applies? 594. Because diversity cases and most of the state law cases in the federal courts are diversity cases by definition involve parties from different states, federal courts must often decide which state's law is to govern. A. General Rule 595. In diversity cases, as to matters for which the federal court is required to follow state law, it will apply the law of the state in which it sits. This law includes the state's choice of law rules, i.e., the rules the state courts use to determine what law to apply to cases such as those involving a non-resident party or events that occurred out of state. Thus, if the state's choice of law rules require application of another state's law, the federal court is to do the same. Claxon Co. v. Stentor Manufacturing Co. 313 U.S. 487 1941. B. Questionable extension of Claxon to statutory interpleader 596. In a companion case decided the same day as Claxon Griffin v. McCoach 313 U.S. 498 1941, the Supreme Court applied the Claxon rule to a case arising within federal statutory interpleader jurisdiction. For discussion of interpleader, see Infra 1E117 et seq. Although Griffin apparently remains the law for federal statutory interpleader actions, no one has defended its application of the conflicts rules of the state in which the federal court sits, since federal statutory interpleader jurisdiction was created precisely because it might not be possible to bring scattered claimants before the same state court. C. Modern reaffirmance of Claxon 597. Despite some academic criticism of the Claxon rule, the Supreme Court strongly and summarily reaffirmed it in an extreme case in which the Texas courts would have followed Cambodian law. Day and Zimmerman, Inc. v. Challoner, 423 U.S. 3/1975. By contrast, the heavily criticized extension of the Claxon rule to statutory interpleader in Griffin, Supra, has not been relitigated at the Supreme Court level. D. Exceptions 598. In some instances, federal legislation may provide a federal choice of law rule. Richards v. United States, 369 U.S. 1/1962, for example, The Federal Tort Claims Act requires courts to apply the law, including choice of law rules, of the place where the allegedly tortious act or omission occurred. 28 U.S.C. 13346b. 8. Determining applicable state law 599. Erie referred to the law of a state as declared by the state's highest court. Often, of course, because a state statute or Supreme Court decision is on point. The state substantive law to be followed by a federal court will be clear. However, in other cases, the state court system may never have faced a question, or only lower state courts may have ruled, or it may seem likely that the state Supreme Court would overrule an old precedent if given the opportunity. A. General Guideline, Proper Regard to State Court Rulings 600. Although the Supreme Court has not recently spoken directly on how federal courts should approach the problem of determining unclear state law, it has stated that proper regard must be given to state court precedents. In some cases, a federal court will not be bound by the ruling of a state intermediate appellate court on a point of state law, and a fortiori not by a state trial court decision. Such courts' opinions are, however, relevant data for ascertaining state law. Commissioner v. Estate of Bosch, 387 U.S., 456, 1967. B. Implementation in light of Erie Ames 601. The determination of unclear state law seems best approached with the Erie twin aims of avoiding forum shopping and inequitable administration of the laws in mind. Adoption of simplistic or rigid tests, e.g., being bound by a recent holding of a state's intermediate appellate court, even if the ruling seems contrary to what the state Supreme Court would probably do, could encourage forum shopping by making available in the federal system law that would not, ultimately, govern in the state system. Therefore, many lower federal courts look to all relevant sources, giving due regard to the varying weights of different authorities within the state system, in an attempt to discern how the state Supreme Court would decide the issue. See, e.g., McKenna v. Ortho Pharmaceutical Corp., 622 F2D 567 3D Sir. 1980. In any event, a federal court is supposed to apply state law and not attempt to change it to what the court thinks might be a better rule. C. No deference to local federal judges 602. The Supreme Court has ruled that federal appellate courts are not to defer to the interpretation of state law by federal trial judges, but must review district courts' state law determinations de novo. Salve Regina College v. Russell, 499 U.S., 225 1991. D. State Certification Laws 603. Many states authorize their highest courts to answer questions of state law certified by federal courts before which cases are pending. Where this procedure is available, a federal court may seek an authoritative answer to uncertain questions about state law rather than speculating on them. See Lehman Bros. v. Shane, 416 U.S., 386 1974. B. Federal Common Law. 1. No Federal General Common Law 604. Erie's repudiation of Swift c. Supra, 545 et seq. included the flat statement, there is no federal general common law. However, the very day Erie was decided, the court held that federal common law governed on the specific issue of apportionment of waters in an interstate stream. Hinderleiter v. La Plata River Co., 304 U.S., 92 1938. The resolution to this apparent contradiction lies in the fact that the federal courts do have authority to create common law in particular areas of federal authority or interest, subject to overruling by Congress. 2. Examples of federal common law areas 605. The range of federal interests and grants of authority that could support federal common law is fairly broad, and the subject receives more extended treatment elsewhere. See Federal Court Summary. A. Borrowed State Law 606. In some cases, federal statutes may be silent as to particular issues arising under them, e.g., statutes of limitations for older federal claims and definitions of family status for purposes of some federal law entitlements. In such cases, the federal courts often fill the interstices in federal law by borrowing the law of the relevant state, as long as that law does not undermine the purposes of the underlying federal law. 1. Illustration Derivative Action Demand Requirement 607. A derivative action is a lawsuit brought by a corporation's shareholders to vindicate corporate rights when the corporation's board of directors has not filed an action. In most states, before filing a derivative action, shareholders must make a demand on the board before they bring the action. However, a number of states have an exception allowing shareholders to bring an action without making a pre-complaint demand if the demand would be futile, e.g., because the suit would be against members of the board. The Federal Investment Company Act allows shareholders to bring certain derivative actions after making demand on the board. The Supreme Court has held that under the Act, the scope of the futility exception to the pre-complaint demand requirement should be borrowed from state law. Cayman v. Kemper Financial Services, Inc., 500 U.S., 1991. B. Authorization by Congress 608. In some areas, e.g., portions of the law of labor relations, the Supreme Court has interpreted congressional legislation as intending that the federal courts develop substantive law to further national uniformity. See Textile Workers Union v. Lincoln Mills, 353 U.S., 448, 1957. C. Sufficient Federal Interest 609. The court sometimes regards the federal government as having a strong enough interest in a transaction that it should be governed by uniform federal common law to further that interest, even in the absence of congressional authorization and despite contrary state law. See, e.g., Clearfield Trust Co. v. United States, 318 U.S., 363, 1943. Federal common law governed on issue of delay in notice of forgery of federal government check. There must, however, be a significant federal interest. See, e.g., Bank of America v. Parnell, 352 U.S., 29, 1956. State law governed in suit between private parties on issue of good faith of holder of previously stolen government bonds. That federal government issued the paper involved in the suit does not by itself suffice to require the creation of uniform federal common law. D. Interstate Disputes 610. In interstate disputes involving governments of or in different states, e.g., disputes over interstate pollution, it may be inappropriate for the law of one of the interested states to govern. The federal courts consequently may develop federal common law when no congressional legislation deals with the area. Illinois v. City of Milwaukee, 406 U.S., 91, 1972. E. United States Foreign Relations 611. When questions of American foreign relations are involved, the need for uniform federal common law may be especially clear. See, e.g., Banco Nacional de Cuba v. Sabatino, 376 U.S., 398, 1964. Exam tip. For some reason, almost everyone who has been to law school seems to remember Erie's admonition that there is no federal general common law. This often results in a knee-jerk response whenever they hear the suggestion that a federal court is to apply federal common law. They respond that there is no such thing. This, of course, is incorrect. Federal common law exists in a significant range of cases, including when Congress has appeared to authorize federal common law development, e.g., labor relations, when there is a strong federal interest in developing a uniform federal common law, e.g., requirements for notice of forgery on government checks. When interstate disputes are involved, e.g., pollution issues, and when American foreign relations are involved. So don't be fooled on an exam question. Remember, federal common law exists in some areas.